Welcome to Chapter 4 class. This is concerning searches. The objectives we're going to cover in this chapter include the ability to identify the constitutional amendment and the two key terms contained therein that restrict investigative searches and seizures. We will illustrate the progression of the common levels of proof required during various stages of the criminal investigative process. We will explain the conditions that justify a legal search, summarize the warrantless search precedents established by Randolph, Terry, Chimel, Riley, Quarles, King, Carroll, Chambers, Hester, Weeks, and Mapp decisions. We will understand what the exclusionary rule is, how it affects investigators, and which cases make it applicable at the federal and state levels. We will diagram different types of exterior search patterns commonly used at crime scenes, and explain how interior crime scene searches are typically conducted, and compare how a search of an arrested suspect differs from a search of a suspect who has not been arrested. The Supreme Court has defined a search as a, quote, a governmental infringement of a legitimate expectation of privacy, end quote. Nevertheless, investigators do make many kinds of searches, and searching is a vital task in most criminal investigations. Through searching, evidence of crime and against criminals is obtained. However, every search must be firmly based on an understanding of the restrictions, which we're going to go into now. Searches and seizures are bound by the Fourth Amendment. A search is an examination of a person, place, or vehicle for contraband, illicit or stolen property, or some evidence of a crime to be used in prosecuting a criminal action or offense, and is, by its very nature, an intrusion into one's privacy. A seizure is taking by law enforcement or other government agent of contraband, evidence of a crime, or even a person via arrest into custody. The Fourth Amendment forbids unreasonable searches and seizures and requires that legal searches and seizures be based on probable cause. That's where it executes a search warrant. The Fourth Amendment strikes a balance between individual liberties and the rights of society. The courts are bound by rules and can admit evidence only if it is obtained constitutionally. Thus, the legality of a search must always be kept in mind during an investigation. Reasonable means sensible, rational, and justifiable. Probable cause exists when facts and circumstances are sufficient in themselves to warrant a person of reasonable caution to believe that a crime has been or is being committed. The totality of circumstances, the principle on which a number of legal assessments are made, include probable cause. A search can be justified and therefore considered legal if any one of the following conditions are met. 1, a search warrant has been issued, or a consent is given, or an officer stops a suspicious person and believes the person may be armed. It could also be that the search is incidental to a lawful arrest, or if an emergency exists. Now I'm going to cover a lot of information on this slide that's not on the slide but is in your text and of course available online, so you do need to make sure that you read about this as well and follow along. To obtain a valid search warrant, officers must appear before a judge, establish that there is probable cause to believe that the location contains evidence of a crime, and specifically describe the evidence. Probable cause is more than reasonable suspicion. Here are explanations of probable cause. First, quote, probable cause is a common sense, non-technical conception that deals with the factual and practical considerations of everyday life on which reasonable and prudent men, not legal tacticians, act, end quote. This was in Scari decision in 2007. Jetmore in 2007 explains probable cause as, quote, less than proof but more than suspicion that a crime is being, has been, or will be committed. Thus, probable cause requires a higher standard than reasonable suspicion, but less than the proof beyond a reasonable doubt required for a conviction in court, end quote. A list of guilt-laden or other facts to build probable cause includes flight, furtive movements, hiding, an attempt to destroy evidence, resistance to officers, evasive answers, unreasonable explanations, contraband or weapons in plain view, a criminal record, police training and experience, unusual or suspicious behavior, and information from citizens. As far as the use of informants, the Supreme Court has established requirements for using informants in establishing probable cause. Two separate tests were established in a case called Aguilar versus Texas in 1964. First, is the informant reliable and credible? And second, is the information believable? This two-pronged approach was upheld in Spinelli versus the United States in 1969. However, the Supreme Court most recently changed the two-pronged test to a totality of the circumstances test, which was ruled in Illinois versus Gates in 1983, which most states have adopted. Note that federal courts are still guided by the two-pronged Aguilar-Spinelli test, and several states also adhere to this more stringent requirement for establishing probable cause. There are other requirements as well. In addition to establishing probable cause for a search, the warrant must contain the reason for requesting it, obviously probable cause, the names of the people presenting the affidavits, the officers, and that can also include a district attorney. What specifically is being sought? Evidence, weapons, drugs, etc. And finally, of course, the signature of the judge issuing the warrant. The warrant must be based on fact and sworn by an officer requesting the warrant with an affidavit. An address and description of the location must be given, for example, 100 Main Street, the ABC Liquor Store, or 12344 Forest Drive, a private home. Warrants can be issued to search and seize for the following: stolen or embezzled property, property designed or intended for use in committing a crime, or property that indicates a crime has been committed or that a particular person has committed a crime. In Grove versus Ramirez in 2004, the Supreme Court sent a message to law enforcement on the importance of paying attention to detail. The Supreme Court ruled that, quote, it is incumbent upon the officer executing a search warrant to ensure the search is lawfully authorized and lawfully conducted, end quote. Once a warrant is obtained, it should be executed promptly. In some states, the warrant is good for a set number of days and is to be executed during daytime hours. There is a night-capped warrant which authorizes a search or arrest at any time, day or night. Night-capped warrants can be served when a suspect is in any public area, regardless of the time. If officers attempting to serve a warrant are not admitted by occupants following a knock notice announcement, forcible entry may be made, but unnecessary damage to the structure may make the entry unreasonable. Now let's talk about the knock and announce rule that I mentioned. Officers are required to knock, announce themselves, and wait a reasonable length of time before attempting entry. In Wilson versus Arkansas in 1995, the court made this centuries-old rule a constitutional mandate. Now, officers may obtain a no-knock warrant if the evidence may be easily destroyed, explosives are present, or other dangers exist. But unnecessary damage to the structure may make the entry unreasonable. This rule is intended to protect citizens' right to privacy, reduce the risk of possible violence to police and residence occupants, and prevent needless destruction of private property. Now, there is case law that applies. In a unanimous ruling in the United States versus Banks in 2003, the Supreme Court upheld the forced entry into a suspected drug dealer's apartment 15 to 20 seconds after police knocked and announced themselves. Also, in 2006, the Supreme Court ruled in Hudson versus Michigan that the Constitution does not require the government to forfeit evidence gathered through illegal no-knock searches while executing a search warrant. In the Hudson case, the police only waited approximately 3 to 5 seconds before making their entry. In effect, the court upheld the evidence, gun and drugs, despite the officer's error in not waiting longer. Officers must still balance the knock, announce, and wait requirements against both officer safety and evidence destruction issues, and the entry must still be reasonable. Video recording of knock, notice, announcements, and entry provides evidence of compliance with the rule, as well as the amount of time that officers waited before entry. Now there's a particularity requirement. In Stanford versus Texas in 1965, it states that a search conducted with a warrant must be limited to the specific area and specific items named in the warrant. During a search conducted with a warrant, items not specified in the warrant may be seized if they are similar to the items described, if they are related to the particular crime described, or if they are contraband. Now there are what are called anticipatory search warrants. The court approved use of an anticipatory search warrant in the United States versus Grubbs in 2006. This is defined as one, quote, based on an affidavit showing probable cause that at some future time, but not presently, certain evidence of crime will be located at a specified place. Now let's talk about search with consent. Searching without a warrant is allowed if consent is given by a person with the authority to do so. This was ruled in United States versus Matlock in 1974. Examples of relationships where third-party consent may be valid include a parent or child, an employer or employee, a host or guest, or spouses. This is what occurred in United States versus Matlock in 1974. Consent was given by a third party. Examples of instances when individuals cannot give valid consent to search include a landlord or tenant, or a hotel employee or hotel guest. If the police believe the person giving the consent has authority, they may act on this belief even though it turns out later the person did not have the authority to do so, and that was ruled on Illinois versus Rodriguez in 1990. The consent must be voluntary and the search limited to areas for which the consent is granted, and that's what was at issue in Illinois versus Rodriguez in 1990. The consent must not be in response to an officer's claim of lawful authority and may not be in response to an officer's command or threat. Silence is not consent. A genuine affirmative reply must also be given. When possible, it is good practice to ask for consent. Under the consent once removed exception to the search warrant requirement, officers can make a warrantless entry to arrest a suspect if consent to enter was given earlier to an undercover officer or informant. Now there can be denial of consent by one resident. In Georgia versus Randolph in 2006, the Supreme Court changed this rule governing some consent searches of private premises. The result was, quote, if any party who is present and has authority to object to the search does object to the search, the police may not conduct the search on the authority of that party who gave consent. In other words, if one person consented and the other person did not, the police cannot search. Now we're going to talk about pat-downs or frisks during a stop. Two situations require police officers to stop and question individuals. First, to investigate suspicious circumstances, or to identify someone who looks like a suspect named in an arrest warrant or whose description has been broadcast in an all-points bulletin or APB. The prime requisite for stopping, questioning, and possibly frisking someone is reasonable suspicion. A stop and frisk are two separate actions, and each must be separately justified. In the Terry decision, the court established that pat-down or frisk is a, quote, protective search for weapons, end quote, and as such must be, quote, confined to a scope of reasonably designed to discover guns, knives, clubs, and other hidden instruments for the assault of a police officer or others, end quote. This is now called a Terry stop. The court warned that a pat-down or frisk is a serious intrusion upon the sanctity of the person which may inflict great indignity and arouse strong resentment and is not to be undertaken lightly. The search in a frisk is sometimes referred to as a safety search. Officers may ask the stopped individual for his or her name. In Hillbell versus 6th Judicial District Court of Nevada, Humboldt County in 2004, the court ruled that the state statutes requiring individuals to identify themselves as part of an investigative stop are constitutional and do not violate the Fourth or Fifth Amendments. Officers do not need to advise individuals of their right to cooperate with police on a bus that has been stopped. This was ruled on in United States versus Drayton in 2002. The court has also ruled in Illinois versus MacArthur in 2001 that officers may detain residents outside their homes until a search warrant can be obtained if necessary. We're now going to discuss search incident to arrest. Every lawful arrest is accompanied by a search of the arrested person to protect the arresting officers and others and to prevent destruction of evidence. The Chimel decision established that a search incidental to a lawful arrest must be made simultaneously with the arrest and must be confined to the area with the suspect's immediate control. This was Chimel versus California in 1969. The police can search within a person's immediate control, which encompasses the area within the person's reach. In Maryland versus Buey in 1990, expanded the area of a premises search following a lawful arrest to ensure officers' safety. The Supreme Court added authority for the police to search areas immediately adjoining the place of arrest. This is called a protective sweep or a buoy sweep, and this is justified when reasonable suspicion exists that another person might be present who poses danger to the arresting officers. The search must be confined to areas where a person might be hiding. In New York versus Belton in 1981, it was established that the vehicle of a person who's been arrested can be searched without a warrant. Now let's talk about searching in an emergency situation. In situations where police officers believe there's probable cause but have no time to secure a warrant, such as if shots are being fired or a person is screaming, they may act on their own discretion. A warrantless search in the absence of a lawful arrest or consent is justified only in emergencies or exigent circumstances where probable cause exists and the search must be conducted immediately. This was ruled on in New York versus Quarles in 1984. The circumstances must include the following three conditions. First, there must be reason to believe a real emergency exists requiring immediate action to protect or preserve life or to prevent serious injury. Next, any entry or search must not be motivated primarily by a wish to find evidence. And third, there must be a connection between the emergency and the area entered or searched. In Mincy versus Arizona in 1978, the Supreme Court stated that the Fourth Amendment does not require police officers to delay a search in the course of an investigation if to do so would gravely endanger their lives or the lives of others. In Brigham City, Utah versus Stewart in 2006, the Supreme Court ruled that law enforcement officers could enter a house without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. In Michigan versus Fisher in 2009, the court further clarified when officers may enter a home under exigent circumstances, exception to the warrant requirement, by specifically identifying the emergency aid requirement. The emergency aid exception does not depend on the officer's subjective intent of the seriousness of the crime they are investigating. What matters is whether officers had an objectively reasonable basis for believing that someone needed medical assistance or was in danger. Now we're going to discuss the warrantless searches of vehicles. The Carroll decision, which was Carroll versus the United States, 1925, established that automobiles may be searched without a warrant if there is probable cause for the search or the vehicle would be gone before a search warrant could be obtained. If probable cause does not exist, the officer may be able to obtain voluntary consent. The driver must be competent to give such consent, and silence is not consent. If at any time the driver rescinds consent, the search must cease. Officers must know their state's laws regarding full searches of vehicles pursuant to issuing a traffic citation. There are pretext stops. The so-called pretext stop is overridden by an officer's probable cause to believe the motorist is or is about to be engaged in criminal activity. probable cause trumps pretext. In terms of searches of passengers in stopped vehicles, passengers' rights during vehicle stops often differ from those of the drivers. This was ruled on in Rutledge in 2007. All passengers in private vehicles are detained at a stop. Passengers may be ordered out and kept from leaving. Passengers may be arrested for joint possession of contraband. Passengers' property and the vehicle may be searched incident to their arrest. The passenger property exception ruling was in Wyoming versus Houghton in 1999, and it stated that an officer may search an automobile passenger's belongings simply because the officer suspects the driver has done something wrong. However, in Brennan versus California in 2007, the Supreme Court reaffirmed what officers already knew, that they must have at least a reasonable suspicion of criminal activity to stop a vehicle. Searches of vehicles incident to and contemporaneous with lawful arrest include New York versus Belton in 1981, which established that the vehicle of a person who's been arrested can be searched without a warrant. Belton has since been limited by Arizona versus Gant in 2009, in which the Supreme Court reduced law enforcement's authority to search the passenger compartment of a vehicle incident to arrest. The bright line rule allowing automatic searches of vehicles incident to the arrest of an occupant has been narrowed to allow to such a search only if the officer has a reasonable belief that the arrestee can gain access to the vehicle or that evidence of a crime of arrest will be found in the vehicle. Although Gant restricts searches incidents to arrest, it has no impact on other warrant exceptions such as consent, exigent circumstances, and the motor vehicle exceptions. In Thornton versus the United States in 2004, the Supreme Court ruled that police can search the passenger compartment of a vehicle incident to arrest when the arrestee was approached after recently occupying that vehicle. Regarding vehicle searches at roadblocks and checkpoints, in the United States versus Martinez-Fuerte in 1976, the Supreme Court ruled that immigration checkpoints at the country's borders were constitutional because they served a national interest, and this interest outweighed the checkpoint's minimal intrusion on driver policy. The functional equivalent doctrine establishes that routine border searches are constitutional at places other than actual borders where travelers frequently enter or leave the country, including international airports. In Brown versus Texas in 1979, the Supreme Court created a balancing test, which is an evaluation of interests and factors to determine the constitutionality of roadblocks using three factors. First, the gravity of the public concerns served by establishing the roadblock. Second, the degree to which the roadblock is likely to succeed in serving the public interest. And third, the severity with which the roadblock interferes with individual liberty. Michigan versus Sitz in 1990 established that sobriety checkpoints to combat drunken driving were reasonable under the Brown balancing test if they met certain guidelines. However, the court ruled in City of Indianapolis versus Edmond in 2000 that checkpoints for drugs are unconstitutional. In Illinois versus Litster in 2004, the court upheld the constitutionality of informational checkpoints. In the United States versus Flores-Montano in 2004, the court ruled that privacy interests do not apply to vehicles crossing the border. Now we'll talk about inventory searches. In Chambers versus Maroney in 1970, it was established that a vehicle may be taken to headquarters to be searched. Officers have the right to inventory vehicles if it is necessary to protect the owner's property, protect the police from disputes and claims that property was stolen or damaged, protect the police and public from danger, and also to determine the owner's identity. Now we'll talk about legal searches in plain sense evidence. The most common type of plain sense evidence is that seen by an officer. Plain view evidence is anywhere officers have a right to be, they have a right to see through the use of their unaided senses. Unconcealed evidence seen by an officer engaged in a lawful activity is admissible in court. An officer cannot use the plain view doctrine to justify the seizure of an object that the warrant in use does not mention. An officer also may seize evidence indicated by a sense other than sight. Officers may seize any contraband they discover during a legal search. Containers can be opened where their outward appearance reveals criminal contents, like a kit of burglar tools or a gun case. By their nature, they do not support a reasonable expectation of privacy because their contents can be inferred from their appearance. Then there is plain touch or feel evidence. The plain feel touch exception is an extension of the plain view exception. If a police officer lawfully pats down a suspect's outer clothing and feels an object that he or she immediately defines as contraband, a warrantless seizure is justified under Minnesota v. Dickerson in 1993. There's also plain smell. Evidence may also be seized if an officer relies on a sense other than sight or touch. If an odor reveals the presence of a seizable object, the object may be seized. Then there's plain hearing. Officers or undercover agents can position themselves in accessible locations where they can overhear criminal conversation without extraordinary listening devices such as wiretaps or parabolic microphones. Anything overheard can be used as evidence. Now we'll talk about unreasonable searches under the exclusionary rule. The exclusionary rule established that courts may not accept evidence obtained by unreasonable search and seizure regardless of its relevance to a case. In Weeks v. the United States in 1914, this made the rule applicable at the federal level. In Mapp v. Ohio in 1961, it made it applicable to all courts. The fruit of the poisonous tree doctrine established that evidence obtained as a result of an earlier illegality must be excluded from trial. There's also the inevitable discovery doctrine. This is derived from Nix v. Williams in 1984, and this doctrine states that if illegally obtained evidence would in all likelihood eventually have been discovered legally, it may be used. There's a good faith exception. This is derived from the United States v. Leon in 1984. This doctrine established that illegally obtained evidence may be admissible if the police were truly not aware they were violating a suspect's Fourth Amendment rights. We're going to talk now about conducting investigatory searches. A successful crime scene search locates, identifies, and preserves all evidence present. The goals of a search include establishing that a crime was committed and what the specific crime was, establishing when the crime was committed, confirming where the crime was committed, such as in a homicide, the crime may not have occurred where the body was found, identifying who committed the crime, explaining how the crime was committed, and suggesting why the crime was committed. It is important that officers recognize the following. A meticulous, properly conducted search usually results in the discovery of evidence. The security measures taken by the first officer at the scene determine whether evidence is discovered intact or after it has been altered or destroyed. During a search, do not change or contaminate physical evidence in any way, or it will be declared inadmissible. It is paramount to maintain the chain of custody of evidence from the initial discovery to the time of trial. Organizing the crime search includes dividing duties, selecting a search pattern, assigning personnel and equipment, and giving instructions. It also includes determining the number of personnel needed, the type of search best suited for the area, and the items most likely to be found, and determining whether the scene was immediately secured and whether the scene is considered to be a true or uncontaminated scene. Physical evidence ranges in size from very large objects to minute substantial traces. Knowing what to search for is indispensable to an effective crime scene search. Physical evidence is anything material and relevant to the crime being investigated. The quote-unquote elephant in a matchbox doctrine requires that searchers consider the probable size and shape of evidence they seek because, for example, large objects cannot be concealed in tiny areas. Now let's talk about search patterns. All search patterns have a common denominator. They are designed to systematically locate any evidence at a crime scene or at any other area where evidence might be found. For exterior searches, you can use a lane search pattern. Partition the area into lanes using stakes and string, or a strip search pattern. If only one officer is available for the search, the pattern can be divided into lanes. There's also a grid search pattern, often used as a modified grid. The circle search begins at the center of an area to be searched and spreads out in ever-widening concentric circles. The zone or sector search pattern is an area divided into equal squares on a map of the same area. Interior searches. Most searches are interior searches, and interior searches go from the general to the specific. The process starts at an entry point, search the floor first, then the walls, and then search the ceilings. When doing building searches, you need to familiarize yourself with the location, discuss a plan of action, access all available resources, think safety first and last, and use extreme caution in what's called the fatal funnel, and I'm going to explain that. Building search and the entry into non-secured areas is one of the most intricate skills that are not routinely taught to police officers, and this was written by Oldham in 2006, page 73. Clear the fatal funnel, which is the zone outside and inside the doorway, quickly. When executing a warrant to search a building, officers should first familiarize themselves with the location and the past record of the person living there. Do not treat the execution of a search warrant as routine. Plan for the worst case scenario. Have a plan before entering the building. Keep light and weapons away from your body. Officers may, for their own safety, detain occupants of the premises while a proper search is conducted. Officers may also require residents to remain outside their homes. Officers should be aware of the ruling in Kelo versus the United States in 2001, which held that thermal scanning of a private residence from outside the residence is considered a search. In California versus Greenwood in 1988, the Supreme Court ruled that containers left on public property are open to search by police without a warrant. The most important factor in determining the legality of a warrantless search trash inspection is the physical location of the retrieved trash. Police cannot trespass on private property to gain access to the trash location. Officers need to know if the trash is within the curtilage of the person's property, which is that part of the property that is not open to the public and is reserved for the property owner exclusively. With vehicle searches, you should remove all occupants from the car or other vehicle, search the area around the vehicle, search the interior, and make sure to take precautions to prevent contamination of evidence. Be sure to return along the other side to the front. So go all the way around the car. Now we're going to discuss suspect searches. If the suspect has not been arrested, confine your search to a pat-down or frisk for weapons. If the suspect has been arrested, make a complete body search for weapons and evidence. Under the Fourth Amendment, officers are permitted to handcuff, detain, and question occupants when executing high-risk search warrants. Before conducting any search, ask the suspect if he or she has anything that could get the officer into trouble, asking specifically about needles or blades. When possible, search a suspect while a cover officer observes. If arresting the suspect, first handcuff and then search. Every search should be done wearing protective gloves. If you arrest a suspect, conduct a complete, thorough body search for both weapons and evidence. Strip searches may be conducted only after an arrest and when the prisoner is in a secure facility. Such searches should be conducted by individuals of the same gender as the suspect and in private, and should follow written guidelines. Cavity searches go beyond the normal strip search and must follow very strict departmental guidelines. Such searches should be conducted by medical personnel. There are inhibitors to a thorough search. The presence of bodily fluids is one factor that may interfere with a complete search. Officers must also be alert to suspects who may spit or bite them. Another inhibitor to thorough searches is fear of needles. Weather can also compromise the thoroughness of a search. In regard to dead body searches, Searching a dead body should be done only after the coroner or medical examiner has arrived and given permission. Do not turn the body over to search for identification or other wounds or evidence. This causes major problems in documenting the body's original position. Search the dead body systematically and completely, including the immediate area around and under the body. With underwater searches, conditions beyond the control of the investigator may dictate what type of search is conducted. So things like metal detectors are a necessity in underwater searches. You run into limited visibility, extreme water temperatures, swift currents and hazardous materials, a crime or accident scene, or again, you might need to use a metal detector because of limited visibility. A dog can be an invaluable resource to a patrol officer. Dogs can be trained to locate suspects, narcotics, explosives, cadavers, and much more. Dogs are good for bomb, chemical, and drug detection, tracking both suspects and lost persons, and finding real and counterfeit money, landmines, people hiding, weapons, buried bodies, fire igniters, accelerants, and in arson cases. Canines are a great force multiplier and a psychological advantage. Now, technology increases every day exponentially, so using technology can make investigations more efficient and effective. However, make sure not to overstep the privacy line that could be the case for shaky legal ground. One example of that is the ongoing argument about the use of drones at the moment. There are some recognized exceptions to not having a search warrant. Situations where no search warrant is required. A no search would be a plain sense, open field, abandoned property, private property delivery, controlled delivery, or exposed characteristics. Independent justification would be consent, probation, or parole, incident to arrest, officer safety, booking, search, and inventory. Exigent circumstances such as rescue, protection of property, imminent destruction of evidence, fresh pursuit, escape prevention, and public safety, or a fleeing target such as a car, van, truck, RV, bus, boat, aircraft, etc., with PC and lawful access. The courts have also identified several special needs exceptions. These exceptions do not fit into other categories. Examples include school searches, searches of highly regulated businesses, like firearms dealers, pawn shops, and junkyards, employment and educational drug screening, and the immediate search for evanescent evidence such as blood alcohol content. So a reminder, we talked a lot about the Fourth Amendment. Officers' actions must be reasonable, outline your details, present the full situation, and take in the totality of the circumstances. Jeb Moore stresses, quote, the ability to skillfully document in writing facts and circumstances that lead to logical inferences and reasonable conclusions remains a professional requirement in criminal investigation. Excellent investigative work is negated and the guilty may walk free if the legal framework on which it was based cannot be adequately explained, end quote. Remember that the Fourth Amendment requires that the officer's actions be reasonable. Clearly outline every detail known to you at the time in your report so the reasonability of your actions will be clear. Now let's go over a brief summary of what we talked about in this chapter, and there's a lot. I covered a lot of material that is not in the slides, and there's an extensive amount of material in your textbook. Make sure that you study it. So to summarize what we covered, we talked about how the Fourth Amendment to the Constitution forbids unreasonable searches and seizures. So investigators must know what constitutes a reasonable or legal search. The scope must be narrow because general searches are unconstitutional. Also, we talked about search patterns that have been developed that help ensure a thorough search, but always be on your guard when doing a search, particularly a frisk down or a stop vehicle search, and we talked about the dangers of building searches as well. Well, that's it for Chapter 4. I appreciate your time and attention, class. As always, I advise you to contact your instructor should you need any clarification on anything or any questions answered. Again, thank you for your time and attention. We'll see you next class.